Hello, this is Mariana O'Brien. I am your instructor in the course of Labor Relations in the Public Sector. I thought that before we start the readings of Module 1, the context of labor relations in the public sector, I should give you some heads up so you can understand more thoroughly the contents of these readings. For the first module, we have assigned 5 readings from our textbook and an additional material about the right to work law in Wyoming. On February 15th, the discussion board 2 is due, and on March 1st, quiz 1 is due. So, why I'm doing this video? The reason is that the textbooks I have selected for this class, one is very theoretical. The Kearney and Mariscal textbook is focused on definition and the historical development of labor relations in the United States, while the Going Public of Brooks and Lipsky is more applied. All the concepts that you will find in the first textbook are already applied in the second book. And because of that, probably students that are registered in the Masters of Public Administration are more familiar with these terms. However, this class is also addressed to students in the undergraduate program. I'm giving you a set of terms that might help you in the understanding of these chapters. First of all, what is labor relations? In our readings, we will find different terms to refer to the same set of relations that employees and employers embark to discuss the terms and conditions of employment. You will find in your literature the terms labor management relations, employee-employer collaboration, etc. When I first started teaching this class, I asked my students the first question: what do you think labor relations is? And especially, what do you think labor relations are in public sector? Immediately, they related the term with unions and strikes and communism. So I would like for you to come to this class with an open mind, with the understanding that what we are going to talk about are those relations that are embarked between employee or employers in order to agree in the terms and conditions of employment. Also, in this class, we will try to show the difference between the private and public sector relations, and of course, the organizational structure behind these two sectors. For example, we will read several chapters referring to the National Labor Relations Board, or NLRB, and the Federal Labor Relations Authority, FLRA. I want you to be very aware that the first deals with the private sector labor relations, while the former relates to the public sector at the federal level. Then again, labor relations are these sets of conversations to discuss and reach to an agreement about the terms and conditions of employment. Also, some of you might be aware that Wyoming prohibits collective bargaining in the public sector, but that does not mean that there are federal statutes that govern labor relations in Wyoming. We see in this map how Wyoming belongs to the Denver Regional Office. Also, I would like you to pay very close attention to the figure that is in our book of Kearney and Mariscal, page 34, explaining the determinants of the labor relations policy in states. In this way, we will understand how the socio-economic environment and the political culture of the citizens of each state determine, of course, the political system, because citizens elect their representative, and the representatives are the one that bring to the legislature the state labor relations policy and the state and local unionization policy. Okay? So with that in mind, we will understand some of the tables in chapter 2 of the Kearney textbook. In addition, I realize that many of these terms that you see in this screen are used in the beginning of these textbooks, assuming that we already know this terminology. But as I mentioned, some of our students are undergraduates, and maybe some of the students from the master program are full-time and didn't get the opportunity to get acquaintance with this terminology. We will read that one of the causes why collective bargaining and unionization haven't evolved so fast in the United States is due to the sovereignty argument. What is the sovereignty argument? In a representative democracy such as the American, the people are sovereign, and their will is served and represented by the elected representative. So, if government through this representative bargain over terms and conditions of employment with a union, then the sovereignty is violated through the illegal delegation of the people's will. Based on the sovereignty argument, many states have banned or prohibited the right of collective bargaining. However, a counter-argument to this is if government representatives or civil servants do not negotiate these terms of employment with a union, then they will make the decision by themselves. And the question is that really the people's will? So we see the arguments for and against the sovereignty argument. Collective bargaining. Collective bargaining is a continuous process in which representatives of the employer, in this case government, and employees, the union, meet jointly to establish the terms and conditions of employment for workers in a bargain unit. But then there are two concepts that need to be explained. The union is the bargain agent with document support of their representative. So they have the right to represent a group of people. But that representation is gained through elections, and everything has to be recorded in the respective authorities. If in a state there are collective bargaining statutes, then would be the Board of Labor Relations of the state. If not, then would be the FLRA. But remember, unions are organizations, and for those who already have taken classes of organizational theories, they would understand that organizations are immersed in an environment, and in order to survive, they have to adapt to the new social, political, and economic environment. Therefore, unions have to assure their viability, compete for membership, they have to evolve with the time in order to be active and useful for their clientele. But what is a bargain unit? The bargain unit is the specific group of employees that are represented by the union. For example, the Teaching Assistants Union at the University of Wyoming. This is an imaginary example. This union only and exclusively represents the teaching assistants of all the departments. They don't represent, for example, the faculty members or the administrative body of employees of the university. The scope of bargaining, in essence, is what unions can and cannot negotiate. In this example, I put 5 bullets. One corresponds to wages, hours, working conditions, polygraph examination, work schedules, decisions about contracting out some of the services that they provide. However, unions cannot negotiate any term that is outside this pre-agreement of the scope of bargaining. For example, the union could not negotiate in regards free lunch for children of the employees. It wasn't part of the primary agreement. They could instead negotiate about wages of hours. They can demand an increase of wages, reduce or make more flexible hours. That is part of the scope of bargaining. We will also read about the management rights or employer's prerogative. They are synonyms. In this negotiation between two parties, the labor and the management, there are points that are outside the scope of bargaining, and they are prohibited from collective negotiation. Usually, these management rights are related to the organization's operation. This is designed under the rationale that when an employee or applicant joins an organization, they know in advance what type of organization they are joining. Employer rights or prerogatives have to do with the traditional management functions. They are entitled to determine the nature of the work, determine the mission of the agency, to name a few. The contract. But what is a contract? The contract is the written agreement of the terms and conditions of employment. But in order to implement a contract, there are some steps or stages. First is the contract negotiation. The union or the association of employees meet the management with their demands. After a period of negotiation, they reach to an agreement. They shake hands and they sign a contract. Then, the contract needs to be ratified by both the bargain unit, meaning the employees who are represented by the union, and second, by the state legislature or city council. The governor of the state has still the right to veto the agreement. And fourth, the contract implementation, how this agreement takes place in the organization. Of course, impasse can occur when parties at a negotiation table cannot reach an agreement. It may occur during contract negotiation. Let's say the union wants to increase the hours from Monday to Thursday so they can leave earlier on Friday. That is part of their scope of bargaining. However, management disagreed with that proposal. And if both parties are not willing to compromise for a solution, a moment in impasse have been reached. Also, impasse can occur during the contract implementation, meaning that the contract says that there will be an increase in wages and it never happens. Well, the union establishes the procedure of grievance. Usually, the grievances that are allowed to be filed are established under what is known as unfair labor practices, or ULPs. These are rights and obligations of the parts of unions, agency management, and employees. If either labor or management fails to perform its obligations to the other party, an unfair labor practice charge may be filed. For example, if in the scope of bargaining it is agreed upon that the unions can negotiate about the wages and management refuses to meet for that purpose, employees are entitled to file an unfair labor practice charge against the agency. And vice versa, if in the contract agreement was established that employees agreed to work 8 hours from Monday to Friday and they don't comply with this agreement, the agency can file an unfair labor practice charge against the employee or the union. So those are the terms that I wanted you to be clear about, so it would be easier to read the chapters. But also, what are the points I would like you to pay special attention? In the Brokan-Lipsky readings, chapter 1, what is important here is how the author explains the relations between employer and employees in a current organizational context. Remember that public organizations have gone through a process of privatization, marketization, and contracted out that has happened through decades after the implementation of the new public management. Also, it compares different employee relations. In addition, this article compares the U.S. employer-employee relations versus other industrialized democracies. It is important to note how in these examples, not only employees' associations can represent their rights. In some cases, there are employer associations who are the ones who sit at the table in negotiation with the unions or the employees' association. It provides a new perspective in similar societies and opens a box of different possibilities in the topic of labor relations. In chapter 9, the author explains the relation between the legal environment and labor management cooperation. It is important how the author uses this term instead of labor relations or employee management relations. Implicitly, the author looks for a common ground where employees and employer drive for high performance in service delivery. It shows that if it's not prohibited by law, then it is not illegal, offering creative solutions. For instance, in states where collective bargaining is prohibited, it is also not prohibited to sit down in a meet and confer setting and talk about the terms of employment. If we see public organizations in the context of service delivery, performance appraisal, employer and employees both are trying to achieve high performance. And finally, these articles, aside that we may agree or disagree with the conclusions, these are samples of how arguments or positions are well documented and supported by evidence. The objective of this is for all students to understand the mechanisms of labor relations in the public sector. It can be either from the perspective of the employee or from the perspective of the employer. But the common ground, no matter in what side of the table you are in, we should try to achieve democratic agreements that will enhance the performance of our organization. Therefore, if we come up with a solution or a proposal, we have to document that proposal with evidence based on scientific proof, on examples that have been tested in different settings at state, federal, or local levels. Only that way we will be successful managers. All right. This is Marianne O'Brien again, and if you need any assistance in this class or any other issue, send me an email or come and visit me at my office hours. Thank you.